If the employer has a self-insured plan, a self-funded plan that is paid out of general assets of the company or the organization, then it's governed solely by federal law and by ERISA, assuming it's a private sector plan. And under ERISA, there's no requirement to cover same-sex partners, and then you have the overlay of the Federal Defense of Marriage Act saying there are no rights for same-sex couples under federal law. So if that's the case, if you're in one of the states that doesn't recognize and you have a self-funded plan, you can essentially do whatever you want with your plan and define it any way you want to either cover same-sex partners or not cover same-sex partners. The tricky part occurs with respect to fully insured plans, so plans that are not paid from general assets but rather are funded by an insurance contract. Even though federal law may govern those plans, and ERISA does govern insured health plans, there's a specific exception from ERISA preemption for state insurance law, and state insurance law is not preempted and would apply to an insured plan. So if you have a fully insured plan in a state that provides some spousal recognition for same-sex partnerships, whether it be same-sex marriage, civil unions, or full rights domestic partnerships, you will have an obligation in those states to offer insured health benefits to same-sex partners to the same extent as you cover opposite-sex partners. So if you have an insured health plan in New York, for example, and you cover employee spouses under that plan, under New York state insurance law, spouse now means same-sex spouse because same-sex marriage is legal there, so you will have to cover same-sex spouses under your New York insured health plan. Another example in the non-marriage context is civil unions. So take, for example, Illinois civil unions. If you have an Illinois company with an Illinois insured health plan, that insured health plan will have to cover same-sex and opposite-sex civil unions to the same extent as it covers spouses. And that's because, again, insurance law applies to the insurance plans, and the state definition of marriage or same-sex partnerships or civil unions in various states would require coverage. That is really the situation where there could be a mandate on an employer to offer benefits. The other mandate area is governmental plans. Government plans are not governed by ERISA, and they are governed by state law. So if you are a state government plan in New York or Massachusetts or somewhere where there's same-sex marriage, your plans will have to cover same-sex spouses to the same extent as opposite-sex spouses. Another type of plan that's really interesting, I'm not sure if we have anybody represented on the phone. I can go into more detail if we do,